You have to learn, though.
Really?
I just got this from the postman. He said, what's the address? I said 1410, 1411. He gives me this for you, from my mom. And then he says, what's your name? I said, Eric. He says, oh, these are for you and her. I said, what day is it? He said, today is the 30th, I think. And then he says, I say, what day is the postmark on here? And he goes, I don't know. What does that say? I don't know. Oh, shit. There's no way to know. I said, can I look online for my, like, arriving mail, like, notice? He's like, I don't know. How am I supposed to know? It's for court. And in court, you know, if it's not the same day it's postmarked as it says on the inside of the envelope, and then I go to look at the envelope, and the envelope for you is torn open. The envelope for me is closed. And once again, I'm not Patrick Murray, defendant Patrick Murray. And then it appears that the court, through inadvertence or clerical error, the minute order of the bank does not properly reflect the court's order. Said minute's order is ordered correct pro nunc-tuorum. Plaintiff has not established the elements of forcible detainer pursuant CCP and is not entitled to a judgment as a matter of law at this time. The order of the court ruling is signed and filed this date and incorporated herein by reference. A courtesy copy of the court's ruling is emailed to counsel Simony Law. What the fuck? There was a case today.
Holy shit. On the 27th.
That was yesterday. Why didn't anybody tell us?
The summary judgment was yesterday?
Why didn't anybody tell us?
I don't know. Well, what? Let's see. Tribal issues a matter of material fact. Okay.
Statement of material facts for proceedings. This is a residential forcible detainer action for the premises. Plaintiff has filed a motion for summary judgment, finding that there are no material disputed issues of fact. In support of its motion, plaintiff provides 3 declarations. The first is from plaintiff's chief executive officer director, and is accompanied by a title report of the property. The second is from the previous owner of the property. No, it's not. Oh, yeah. Okay. And original plaintiff in the action is accompanied by a copy of an agent visual inspection disclosure statement. A motion for summary judgment may be made at any time after the I'm giving 5-day notice. In moving for summary judgment, plaintiff of showing that there is no defense. Move fast after.
Yeah. Okay. Can you keep reading out loud?
Yeah.
Yeah, go faster.
Oh.
Mhm. That's okay.
In moving a summary judgment, a plaintiff has met his burden of showing that there is no defense to the cause of action. If he has proved each element of the cause of action entitling him to judgment on the cause of action, the plaintiff must present evidence that would require a reasonable trier of fact. We should ask for it to be prejudice.
Mm-hmm.
And we should move fast.
Mm-hmm.
Like tonight, just clean house. We would require, and we need to fucking serve them with a forcible detainer now.
Mm-hmm.
In our quiet title now. They're weak. They're strong. Would require a reasonable trier of fact to find any underlying material fact, more likely than not. Otherwise, he would not be entitled to judgment as a matter of law. But we are, but would have one to present his evidence to trier of fact. Once the plaintiff has met the burden shifts to the defendant to show that a triable issue of one or more material facts exists into the cause of action or defense thereto. There is a triable issue of material fact if and only if the evidence would allow a reasonable trier of fact to find underlying fact in favor of the party opposing motion with a applicable standard of proof. The defendant shall not rely upon allegations or denials of its pleadings to show that triable issue of material fact exists, but instead shall set forth the specific facts shown in a triable issue of material fact exists, a cause of action entered into. Motion for summary judgment shall be granted if all the papers submitted show that there is no triable issue as to material fact, but that the moving party is entitled to a judgment of... Do we still have court?
On the 5th, yeah.
We still do?
Yeah.
We do?
Yes.
Even though this is...
This is a hearing on the motion.
Motion shall be granted if all the papers submitted show that there is no triable issue as to material fact. The moving party is entitled to a judgment of material fact. The court shall consider all the evidence set forth in the papers except for the evidence to which objections have been made. Stated by the court, all interference is reasonably deducible from the evidence except summary judgment shall not be granted by the court based on inference reasonable deducibles from the evidence as contradicted by other inferences of or evidence that arise of triable issues of material fact. I'm just skimming it.
Mm-hmm.
Every person is guilty of a forcible detainer who is either by force, by means of threats, or unlawfully holds or keeps up possession of any real property, whether the same is acquired peaceably or otherwise. Who in the night or during the absence of occupant of any land unlawfully enters real property, and who demands, and after demand made the surrender thereof, for a period of 5 days refuses to surrender the same to such former occupant. What's that one?
Yeah.
Who in the night or during the absence of the occupant of any land unlawfully enters
Hi.
on real property, and after demand made for the surrender thereof for a period of 5 days refuses to surrender the same to the former occupant. The occupant of real property within the meaning of this section is one who within 5 days preceding such unlawful entry. The occupant of real property within the meaning of this section is one who within 5 days of the unlawful entry lives peaceably and undisturbed possession of such land within peaceable and the occupant of real property within the meaning of this is one 5 days preceding such unlawful entry was in peaceable and undisturbed possession of. It's us.
Yeah, absolutely. Italics added. As the italicized language in the statute makes it clear, a plaintiff cannot prevail on a cause of action for forcible detainer unless an unlawful entry has occurred.
Forcible detainer found where entry was without consent.
For entry. Mm-hmm.
Is this from Calora's, like...
Mm-hmm. Yeah.
Calora, you're, like, surprising me.
Yeah.
I'm freezing my ass off.
Yeah.
Lauren Cow was... Can we read it in
Yeah,
time?
that's consent.
Markinson.
Ah, come on, man, I'm excited. Let's go.
Yeah, we'll read this one out loud. Because you know, remember that one video where those a couple, they're like,
Yeah. Totally. Let's have one.